What is a Section 9 petition under the Arbitration and Conciliation Act? Do you file such a petition before a court or before an arbitrator? What is the purpose behind filing a Section 9 petition? These are some of the discussions that we're going to be talking about in today's video. Hi everybody, my name is Ramana Reddy and I'm a practicing lawyer in the High Court of Telangana. On this channel, I help you by simplifying complex legal arbitration concepts. For tips, tricks, and more arbitration-related information, make sure you hit the subscribe button below. So let's begin with an example. I think that will clarify the whole issue. So let's take a simple example. Let's say that you are out to buy a painting from an artist. You meet an artist, you strike a deal, you want to buy a painting, and both of you enter into a contract. Now let's say that the contract has an arbitration clause. And now after you've signed the contract, you find out that the painter or the artist is somehow trying to sell that same painting to a third party. Now, in such situation, what do you do? Now, generally, if there was no arbitration clause, you would just rush to court and you would say, you would get an injunction preventing him from selling the painting to a third party. But in this case, you have an arbitration clause, so you have to go up before an arbitrator. But the practical problem is the arbitrator is not yet appointed. If the arbitrator was appointed and selected, which does take some time, then in such a case, you just approach the arbitrator and told him that, look, he's trying to sell the painting, I have a contract, prevent him from selling the painting. But in our case, the arbitrator is not yet appointed. So in such a situation, what do you do? This is where Section 9 comes into play. Under Section 9 of the Arbitration and Conciliation Act, it is basically a stopgap arrangement where you sense that something is about to go wrong, but the arbitrator is not appointed yet. So, you don't have to wait till the arbitrator is appointed. What you can do is you can approach a court and you could say that, look, I have a contract with the painter. Let him not alienate the painting to a third party. Does this mean that you've automatically won the case? No, of course not. Because ultimately an arbitrator will be appointed and there will be, a whole case around whether you are entitled for the painting or not entitled for the painting, because, and that is an ultimate decision after, pleadings, evidence, arguments, and so on. But in the meantime, if the artist is allowed to sell the painting, then the very subject matter of the dispute, is gone. And that is a problem because, when a third party comes into picture, you create, there's duplication of litigation, things get more complicated, and you may never actually get the painting, even if you end up winning the arbitration. So the Section 9 provision is designed, like I said, as a stopgap arrangement to make sure that whatever is the subject matter of the dispute is protected. Now there could be, and you can multiply this across, several sectors. Let's say, for example, that somebody owes you money, and that person is trying to, transfer that money somewhere else, then you can file a Section 9 petition trying to prevent them from transferring that money to somebody else. Or let's say you're a contractor and you've given a bank guarantee or, a performance guarantee that you will do work and that the other party will not invoke unless there's a breach, and you realize that the other party is going to invoke the bank guarantee. If you wait for the entire bank guarantee to be invoked, then, the purpose of arbitration may be frustrated. So you could just go to a Section 9 court. Or to take a more simple example, that let's say that there's a lease deal between a landlord and a tenant, and the tenant finds out that the landlord is trying to rent the same property to a third party, even though there's already a registered lease deed with the tenant. Then in such a case, then you can go to a Section 9 court to prevent the landlord from renting the property to a third party. Or to take an even extreme situation, it says that the landlord is planning to demolish the entire building after having entered into a lease with you. Then since the arbitrator is not yet appointed, you can still rush to the Section 9 court and say that, look, I have a contract, there is an arbitration clause, which is why I'm here. At least protect the building until the case is resolved this way or that way. It doesn't matter. But if the building itself is gone, what are we going to be fighting about? So Section 9 basically is a stopgap arrangement, and it is used to preserve the subject matter in dispute, or the sum in dispute, or the amounts in dispute, and so on and so forth. Now, technically speaking, if you read the section, that is section 9, it will say that you can approach a section 9 court both before, during, and after an arbitrator is appointed. But generally speaking, courts will not entertain a section 9 petition once the arbitral tribunal or the arbitrator is appointed. So let's go back to the painting example. So let's say that the arbitrator is not yet appointed. So you rush to court and say, look, the arbitrator is not yet appointed, so please protect the painting. And the court, may say yes or no, but at least the court will entertain the section 9 petition. But contrast that with, if the arbitrator is already appointed and you still go to the section 9 court, the court will say, why are you coming here? The whole purpose of appointing an arbitrator is so that you can go before the arbitrator and you can resolve your disputes. So don't come here. So even though there are some rare situations where you can approach a section 9 court, even after the tribunal is constituted, generally speaking, section 9s only come into play before the arbitral tribunal is constituted. Now, one case, for example, where after the tribunal is constituted, you could go to the section 9 court. Let's say that the arbitrator has had a heart attack, or he's not well, or he's traveling, or he's in another country, and for whatever reason you cannot approach the arbitral tribunal or the arbitrator, even though he has been appointed, and there is some urgency, and you cannot wait for the arbitrator to come back. In such a situation, you can go to the section 9 court. But that again is a high standard. It's not a very common situation. So generally speaking, section 9 petitions are entertained only before the arbitral tribunal is constituted. Once the arbitral tribunal is constituted, you will have to file a section 17 petition if you have any urgency, and we'll talk about section 17 in some other video. But a section 9 petition generally only before the arbitrator is appointed. Now, what is the standard of proof? What is the, what do you have to show to get a section 9 order? You don't have to show actual proof that the artist is planning to sell the painting, or the builder is planning to, demolish the building. You don't have to show, for example, that the builder has started demolition of one portion of the building and then rush to court. If there is a strong possibility that the painter is going to sell the painting, if there are some set of facts to support that there's a strong possibility that the painter is going to sell the painting to a third party, or that the builder is going to demolish the building, and you have a lease deed with him, then in such a situation, you can go to the section 9 court. You don't have to show actual proof. Strong possibility is sufficient. I hope that video was helpful. That's just a general overview of the section 9 petition. If you'd like more information, make sure you hit the link in the description below. Thank you for watching.